We'll be joined shortly by our Vice Chair, Delegate Ken Kerr. Today is Tuesday, February 24th, and we will begin with our bill hearings with HB 587, Delegate Phillips. And I know we're also joined by our Treasurer. Good to see you. And I believe also Michelle Lambert from the Comptroller's Office.
Ooh. It's a party in here. Good afternoon, Madam Chair, Mr. Vice Chair. It is a pleasure to be here with you and feel glee. I would have gone with Lego, wasn't my choice. So good afternoon, and thank you for the opportunity to present House Bill 587, and I'm going to ask you all for a favorable report. This bill restores oversight by the Maryland Board of Public Works over large transportation procurements that occur without elected or independent review. The impetus for this legislation, I'm going to give you the story, was the tragic collapse of the Francis Scott Key Bridge. In the days following that disaster, I always look at procurement. That's just one of the things that I follow. I asked a straightforward question: who was working on the bridge and under what procurement authority? When I raised the matter with members of the Board of Public Works and staff, I learned that a procurement approaching $1 billion had not been before them. It really concerned me because that procurement carried a MBE participation goal of 3%. Some argued that urgency required speed, but the Board of Public Works handles emergency procurements every week. Emergency review is not foreign to the board, it is routine. The explanation just did not square with me. As I dug deeper, I discovered this was not unique to the Key Bridge. Under current law, capital expenditures by MDOT and one of the specific agencies, MDTA, in conjunction with roads, bridges, and highways, are exempt from the Board of Public Works oversight. House Bill 587 narrows that exemption for projects valued at $500,000 or more, and we would return that approval to the Board of Public Works. Perspective: in calendar years 2023 and 2024 alone, MDOT and MDTA awarded 193 road, bridge, and highway contracts totaling more than $1.5 billion. The median contract was $3.6 million. The average contract was $8 million. These are some of the largest capital expenditures made in the state of Maryland, yet they receive no elected fiscal oversight. The Maryland Constitution entrusts the Board of Public Works, comprised of the governor, the comptroller, and the treasurer, with supervisory authority over public expenditures for a reason. It is a structural check. It is a safeguard. It is good government. Last year, MDOT argued that requiring board approval would delay projects and increase administrative burden. This year's fiscal note estimates the cost at approximately $270,000 in FY27 for additional staffing. That is a fraction of 1% of the $1.5 billion in contracts at issue. The Board of Public Works has indicated it can manage the increased volume with existing resources. MDOT also points to the Consolidated Transportation Program, federal oversight, NEPA review, and the MDTA board as an evidence of transparency. But programming a project is not the same as approving a contract award. Federal review is not the same as Maryland constitutional oversight. An internal modal board is not the same as the Board of Public Works. This bill does not eliminate efficiency. It does not micromanage MDOT. It simply ensures that when we are awarding contracts worth hundreds of millions of dollars, when we are obligating public trust funds and setting MBE goals that shape economic opportunity, those decisions are visible and accountable. If a $10 million IT contract must come before the Board of Public Works, why shouldn't a $300 million bridge contract? House Bill 587 reaffirms constitutional balance, strengthens public trust, and ensures transparency in some of the largest expenditures in the state's budget. This, in my mind, is good government, and I respectfully request a favorable report. Thank you.
Good afternoon, Madam Chair, members of the committee. You have my written testimony, and I may come back to that, but I want to get to something and ask you to ask yourselves and possibly the people that come after us this question. I looked at the fiscal note, and knowing that the current fiscal climate that we're in, well, fiscal notes are always important, but certainly as they are now. And one of the things, if you go to the Maryland Department of Transportation section of the fiscal note, and look at the, I believe it's the third sentence in that first paragraph, it says, considering the advance notice of 4.5 weeks that is required to put an item on BPW's agenda, plus an extra 5 weeks of MDOT to do internal reviews prior to submission, the awards of affected construction contracts could be delayed by at least 2 months. All right, I have a problem with that on 2 levels. First of all, it's patently false, point blank, and I know the fiscal writer just went off what they were told. It does not take 4.5 weeks for an item to be put on BPW's agenda. I know that because I'm on BPW. We require, no, I won't even say we require, we ask for 12 calendar days. Not business days, 12 calendar days. So that's less than 2 weeks. However, even though that's sort of the ask or the practice, they can bring items up to 2 days before our meeting and have them put on the agenda. And then within that, if they want to do it, say maybe the day before, they just need to get 2 members of the Board of Public Works to agree to it. So I don't know where 4.5 weeks came from, but I suspect what they're doing, and because I've had this problem in other committees, what they do is their internal process requires them to do all of these things, in addition, I guess, to the 5 weeks they've noticed on here. But when they bring an item before BPW, I guess they're requiring a more rigorous process than if they just take it directly to the street, which raises another issue. Whatever process you have to bring before the Board of Public Works, that should be your process if you don't have to take it before the Board of Public Works. What this implies is that, well, if we're going before those jokers, we got to make sure our stuff is together. If we're taking it directly to the street, we can skip a whole lot of steps. I'm not saying that that's what it is, but that's what this is implying, that because they have to come before the Board of Public Works, now we have to be a bit more prepared, or now we have to do other things. Those things should be done regardless of whether or not it comes before the Board of Public Works. Secondly, to show that we're not unreasonable and so forth, we've heard from the last 2 administrations that the threshold is too low. $200,000 is too low. I think it's been however many years before any of you all were elected. I can say that, probably even before me, that it was set at $200,000. I think at our last Board of Public Works meeting, the comptroller and I, we negotiated, if you will, or we came to a compromise with the administration that the threshold is being raised to $500,000. So that timeline that they're telling you all that it takes, that's going to be, in my opinion, from what we were told in the negotiations, that will be greatly lessened because less projects will be coming to the Board of Public Works. The only things that I really asked was, A, look after, make sure that we have a close eye on our MBE program and make sure that we're watching to make sure that the people are getting full value for the contracts. If we're going to, try to make this process more efficiently, we don't want to miss steps in terms of making sure the people are getting full value for their money. So I I wanted you all to just take note of that and possibly to even ask that question about process. What is it that's different about the Board of Public Works going through that versus going directly to the street? But all that additional time, that is not, and I can't emphasize that strongly enough, that is not required by the Board of Public Works. We ask for 12 days notice. You can do it up to, on your own, up to 2 days before our hearing, and anything less than 2 days, you know, you just need the majority of the board to be willing to accept that. So we've bent over backwards, I think, to accommodate not just MDOT, but all agencies in terms of allowing more so they can be more efficient, more expedient to get their projects done. Again, you have my written testimony. I don't want to belabor my time up here, so I won't go into that. But it's actually pretty good testimony. So if you guys can read it, I know Delegate Fisher will, but if the rest of you all can read it, I won't have to apologize to my staff for not doing it. But thank you for your time. I appreciate it.
Great. It's always hard to go after Mr. Treasurer. Good afternoon, Madam Chair, Mr. Vice Chair, members of the committee. For the record, Michelle Lambert, Director of the Board of Public Works for Comptroller of Maryland, here on behalf of the Comptroller in support of House Bill 587. For more than 200 years, our state's constitution and you all have trusted the Board of Public Works to provide Marylanders with transparency and accountability for major state projects. It's a unique responsibility that members of the board take incredibly seriously. Almost every contract valued over $200,000 right now or more comes before the board, compromised with the governor, the comptroller, and the treasurer, to ensure these expenditures are appropriate, fiscally responsible, fair, and lawful. These are public meetings. They provide visibility into state spending that is unique in Maryland. But here's the problem. For some of our state's most significant projects, roads, bridges, highways, the board has no oversight. You've already heard this. The board has no review of spending on the Key Bridge. Yet last week, the board approved 149 items totaling over $600 million, including $50 million for sewer reconstruction, $61 million for Pimlico reconstruction, and even $28 million for MDTA contractors to perform site inspections. Yet the board does not have authority over MDTA's capital expenditures. That doesn't make sense. And the question is why? This exception was originally from 1939. Which is a long time ago, but also decades before MDOT even existed, and it's just never been questioned since. House Bill 587 fixes that. It requires MDOT contracts valued at $500,000 or more to receive the same public review process as every other state contract. You'll hear concerns about delays. I share the Treasurer's view that this change will not cause delays. Board approval is one of the last steps in the process. The last step to hear from communities, the last step to check DBE goals, the last step to ask questions, but let's be clear, it's the last step. I do want to emphasize the board meets every 2 weeks, as the treasurer said, and has a process for hand carry items and walk-on items, and I can assure you that we can handle this level of work at the board level. So given the uptick in concern about state spending over the past year, it's more important than ever to have transparency and accountability for all states' largest projects. The comptroller urges a favorable report of House Bill 587. Thanks.
Thank you very much. We have a question from Delegate Ruth.
Thank you, Madam.
Okay. Delegate Chisholm.
Thank you, Madam Chair. Good to see you guys. Thanks for bringing the bill. Mr. Treasurer, you said something that piqued my curiosity. You said the fiscal note writer wrote it. I know he's told to do that. Who would tell the fiscal note writer to do that?
No. That the fiscal note writer, they call, like, when they're preparing the fiscal note, they call the various agencies to get feedback. So when they put it on, so in this case, I mean, I don't want to speak for the writer, but I'm sure he contacted, because it affected MDOT, he called them and maybe asked what impact or whatever the comments. But I don't want it to sound as if they're told, like, this is what you have to write. The information that they use, they come from the department. So I'm sure he or she contacted the department, and this was the information he was provided.
Okay, I thought you were going to give me some insight to some puzzling questions I have about
Oh,
this
no,
promotion
I'm not
myself.
stepping into that, sir.
Thank you very much. Just seeing if there's any more questions from the committee. Seeing no more questions. Seeing no more questions. It's good to see you, Secretary Treasurer. Excuse me.
Thank you very
Great to see you,
much.
Michelle. Thank you, Delegate, for the bill.
Thank you, Madam Chair. Thank you to GLEAP.
Absolutely. That concludes our bill hearing for HB 587. We will move next to HB 640. And we have departmental bill DB. Oh, there she is. Good to see y'all.
Yep. Okay. Good afternoon, Madam Chair, Mr. Vice Chair, and members of the committee. My name is Elizabeth Sachs, and I am the Director of Government Modernization in the Governor's Office of Performance Improvement. Streamlining government operations has been a hallmark of the Moore-Miller administration, and last year, the governor issued an executive order launching the Government Modernization Initiative, a partnership between the Office of Performance Improvement and DBM. And to date, we have actually achieved $29 million in savings, and we're looking to achieve 50 by the end of the fiscal year. In addition to our cost savings work, we were asked to sort of quarterback an ongoing effort to identify outdated boards, commissions, and some reporting requirements in statute that could use amendment. And so as a result, HB 640 proposes repealing, but more so modifying 20 boards and commissions, and then aspects of 18 mandated reporting requirements. We also have 3 additional amendments today. This process was in full engagement with state agencies, and it did span 2 years. Beginning in May of 2024, agencies were asked to identify lists of councils, task forces, commissions, boards, many of which I will say, having looked at the spreadsheets, they want to keep doing. But there were some where there were aspects that were either duplicative, inefficient, or in some cases just completely outdated. My team took this on in last summer, July of 2025, went back to the agencies to confirm their perspectives that they'd shared the summer before, and we worked back and forth to resolve any discrepancies, ask for additional clarity, and that is when this bill took shape. In addition, last summer, we looked at reporting requirements only for the 5 largest agencies, and all of which happen to have 30 or more mandated reports. And they were asked on those, for those agencies to look at the duplicative nature of any reports, any due date changes, and that's what's reflected in the bill. So these are primarily modifications, in some cases to repeal, but mostly where there's duplication or due dates that don't make sense. Some agencies have asked to change their membership. All of these changes are summarized in the charts that are attached to the testimony. And in the last few days, there are 2 additional reporting requirement changes proposed for amendment and 1 technical amendment that was submitted by MDH. So I respectfully ask for a favorable report on this bill and happy to answer any questions.
Thank you very much.
And I am Hannah Dyer, Deputy Legislative Officer for the Governor, and I am just here to help with questions.
Great. Thank you so much, Ms. Saxon. Good to see Ms. Dyer. We have a question from Delegate Crutchfield.
Thank you very much, Madam Chair. Just a quick question. What were the amendments? Can you tell us exactly what they were?
Sure. So they're in both the testimony from DBM and MDH. One is so 2 of the amendments relate to changes for reporting requirements. One for the Maryland Loan Assistance Repayment Program Council to amend the frequency of the report from every year to every 3 years. And this recommendation was included in the last annual report from that council. And then the other reporting requirement change is to the tax credit for preceptors programs. So this applies to physicians, student preceptors, nurse practitioner, student preceptors, registered nurse and licensed practical nurse, and physician assistant student preceptors. And this proposal is to change the due date from January 31st to March 1st to align with the tax credit cycle better. And then the 1 technical amendment that Elizabeth mentioned relates to the Cannabis Public Health Advisory Council and correcting that it is now under DOSA.
Thank you.
Delegate Fisher.
Thank you, Madam Chairwoman. On page 18, the highlighted language, line 20, on or before September 1 of each year, beginning in 2027, each county board shall submit to the department a written report containing the number of students that require additional support to meet grade 3 literacy proficiency. Can you explain the purpose of
Sure.
what has changed?
Yeah, so let us just make sure we are referring to our right line here. So this is, relates to the Specialized Intervention Services report. It's a mandated report change. This information is already compiled through a separate process.
Okay, so it's already being done, correct?
Yes.
All right. And, okay, thank you.
Okay, thank you. Seeing no more questions from the committee, this concludes the bill hearing for HB 640. Thank you both so much for presenting the bill. We'll move next to HB 269. We have the commissioner here to present this bill from the State Ethics Commission. Good afternoon.
Hi, good afternoon. All right. Okay, good afternoon, Chair Wells, Vice Chair Kerr, members of the committee. My name is Jennifer Alger. I'm the Executive Director of the Maryland State Ethics Commission, and I'm pleased to be joined on this panel by the Deputy State Court Administrator, Nancy Faulkner, from the Administrative Office of the Courts. We're here today in support of the State Ethics Commission's lone departmental bill this year, House Bill 269. It's important to emphasize that this legislation does not have any fiscal impact on either the State Ethics Commission or the Administrative Office of the Court, so it's government efficiency at no extra cost this year. The bill clarifies that the Administrative Office of the Court administers the financial disclosure provisions and public record inspection provisions of the ethics law for judicial officers and candidates to be judicial officers. State judicial officials file their financial disclosure statements electronically through a system that is exclusively maintained and administered by the Administrative Office of the Court. The State Ethics Commission does not have access to that system and has no authority over the judicial officials. Currently, Section 5610C of the Ethics Law requires that a copy of each financial disclosure filed by a state judicial official be transmitted by the Administrative Office of the Court to the State Ethics Commission. This legislation seeks to remove that requirement. The Administrative Office of the Court is in the best position to establish both procedures for public inspection of these financial disclosure systems and also to provide prompt and direct notification to judicial officials if their forms are reviewed. The State Ethics Commission does not have that same ability. House Bill 269 does not change the disclosure requirements for judicial officials and candidates. House Bill 269 does not remove a citizen's ability to inspect these records. The legislation preserves transparency, streamlines administrative efficiency, and enhances security for financial disclosure filers by ensuring the most direct and prompt notification process. And again, and importantly, the legislation does not have a fiscal impact on either of our agencies. The State Ethics Commission thanks the committee for consideration of this departmental legislation and seeks a favorable report. Thank you.
Thank you. Good afternoon. I am Nancy Faulkner, the Deputy State Court Administrator with the Maryland Judiciary. I am here today to testify in support of House Bill 269. The bill will help streamline managing financial disclosure statements within the judicial branch. Current law requires the judiciary to send copies of the financial disclosure statements of judges, judicial appointees, and judicial candidates to the State Ethics Commission. The process is redundant because the judiciary already maintains permanent copies of the financial disclosures and makes them available for public inspection. Current law places an unnecessary administrative burden on the State Ethics Commission, and it duplicates the work that the judiciary is already doing. The bill relieves the State Ethics Commission of the obligation and places it where it belongs, with the judiciary alone. The judiciary is well positioned to carry out this responsibility using its existing resources. We are grateful that this bill also clarifies the authority of the Supreme Court or its designee to carry out the important work. We join our colleagues on this panel, and we urge you to pass House Bill 269. And I thank you for the opportunity today, and I welcome any questions.
Thank you very much. Just seeing if we have any questions from the Delegate Schmidt.
Thank you, Madam Chair, and thank you for the bill. I totally understand the crux of it. It's my understanding there's been some conversation regarding the term judicial officials. You had brought that up a little bit. I know that some other committees are working on some bills where judicial official has this broad definition from enforcement and border patrol and other things. And I know that's not the premise of this, but I just want you to be aware that there is some conversation regarding some language that could have some crossover there.
Thank you. Judicial official, as it's defined in the public ethics law, is the judges of the various state courts and then appointed judicial officers, orphans court judges, commissioners.
Or candidates for those.
Yeah.
Sure.
So
Okay.
Defined under the ethics law, that's what it would be.
Yeah, and I understand that. I just want to make sure there's not a misunderstanding with other things, but thank you.
Thank you.
Thank you very much. All right, seeing no other, I know we had a virtual testimony. They are unable to join Dr. Kashina A. Cross. With that, this concludes the bill hearing for HB 269. Thank you both so much for your testimony.
Thank you
for the bill, for presenting it. We'll move next to Delegate Simpson, HB 403. Delegate Simpson, do you have a sponsor panel? I see a few people here.
Yes, I think our
Right
state's
now.
attorney, Joyce, might not be able to make it because
Okay.
she's over in judiciary.
Okay, and then I think, is there one of your panelists is virtual, Amanda Stone-Gines? Okay, thank you.
All right.
You may begin.
Thank you, Madam Chair, and thank you, Vice Chair and members of the Government, Labor, and Elections Committee. I am here to respectfully request a favorable report on House Bill 403, the Public Information Act divorce records. Just to be clear, the cross-file has passed unanimously from the judicial proceedings on Friday and moved to third reader today in the Senate, just FYI. So we would like divorce records to understand include children's names, ages, social security numbers, dates of birth, other identifying information, bank financial records, driver's license, cell phone numbers, and so much more are included in divorce records. What we are asking for is for divorce records to have the consistent and the protection of similar records such as child records of adoption, welfare, and student records. We know, I did look at Maryland Judiciary had indicated that were we putting it in the right place, which would have put it back in Judiciary, which is my committee, which would be great. But actually, talking to counsel, this is more consistent with, actually, as you will hear, this was a constituent requested legislation for a specific issue that occurred. It is protecting divorce records from being disclosed from anyone who's not actually a party to the case. And this bill has no impact on our state and local operations or finances. And we, feel that people should not have to worry about whether their information ends up on the internet solely because of a divorce record. This is, it should not have happened. There are supposed to be safeguards, but unfortunately, most people do not know that they are able to request their records to be sealed. So we want to make sure that that's where they start. If they're going to be released, that everybody has knowledge of it and that it is the courts that are releasing those records. Thank you very much. I urge a favorable report.
Next, okay. Thank you. Good afternoon. My name is Ray Gallagher. I am a current member of the Board of Education in Frederick County. Obviously, this is not an education-related bill, but I'm here to share a story that is relevant to my position on the board. Last year, I served as the president during a time when a local individual who's well known for harassing local public officials began attending our meetings. Due to his repeated use of vulgarity and threats, I had to have him removed by our sheriff's deputy on multiple occasions. He posted various content on his social media that directly targeted me, which led to me receiving incredibly nasty and vulgar messages, including direct death threats that were investigated by our local sheriff and sheriff in other states. During this time, I also had filed for divorce. Shortly after my divorce record was finalized, this individual went to the courthouse and requested a full copy of the records. He was given these records except for financial and custody agreements. He subsequently posted my ex-husband's cell phone number online and encouraged his followers to contact him, which they did, which is how we found out that he had gained access to this information. He sent a full scanned copy of the document to all of the elected county and Board of Education members in both Washington and Frederick counties, and then he posted details of the agreement on social media and sent it via email to anybody who requested a copy. The worst part of this is that my minor children's information was included in those records. The process for filing divorce is incredibly painful, and I don't believe anybody outside of those parties who are directly related should have any access to these divorce records unless there is a specific reason for them to do so. I urge you to vote favorably on HB 403 for the protection of privacy rights. Thank you.
Thank you. We'll take questions after we hear from your virtual panelists. Ms. Amanda Stone-Gines, you have 2 minutes.
Thank you. Good afternoon. My name is Amanda Stone-Janez, and I'm a resident of Middletown in Frederick County. I'm also a close friend of Ms. Gallagher, who spoke before me. Ms. Gallagher is a dedicated public servant, yet the absence of adequate privacy protections in Maryland's divorce records allowed her and her family's highly personal and confidential information to be exposed and exploited. As a result, Ms. Gallagher and others involved in her divorce received vulgar messages, including direct threats of violence and death. Her family became targets solely because their private information was made publicly accessible. My own personal data was part of this public exposure. Divorce is already an intensely sensitive and emotional process. The public release of private details, particularly information involving minor children, reveals a serious gap in our public information laws. Allowing individuals who are not parties to a divorce to access such records opens the door for misuse by bad actors with harmful intentions. There is no legitimate reason for members of the public to have access to deeply personal information, such as financial records or custody arrangements. At least 20 other states have enacted laws to protect the privacy of individuals involved in divorce proceedings. I respectfully urge Maryland to follow their lead. There is no public benefit to making detailed divorce records widely accessible, and doing so puts families at unnecessary risk. I ask this committee to issue a favorable report on House Bill 403 and take an important step toward protecting the privacy and safety of Marylanders. Thank you so much for your time and consideration.
Thank you very much. Just seeing if there's any questions from the committee for the bill sponsor for her panel. All right, seeing none, we'll move on to the unfavorable testimony for the bill. Thank you so much.
Thank you.
Delegate, to your panel. We have with us Michelle Smith, and we have Otis Bill Otabi Wifdren. And I believe we have one virtual, Rebecca Snyder, or actually Rebecca's here in person. Okay, you can come up, Ms. Snyder. You may begin, Ms. Smith.
Thank you. Madam Chair, Mr. Vice Chair, my name is Michelle Smith. I'm here on behalf of the Maryland State Bar Association Family Law Section Council. It is my first time testifying before this esteemed committee. Hello, everyone. Thank you for your time and attention on this bill. We are unfavorable today. We're urging you to issue an unfavorable report. While it pains me to do so because the story that you've just been told is gripping and is terrible. It is my understanding, after speaking to some members of the Anne Arundel County Clerk's Office, that this could have been avoided if the clerk in the particular circumstance had done his or her job adequately under the current law. So we would urge an unfavorable report because we do not believe this legislation, A, is needed, and B, is tailored well enough to create the outcome that the sponsor is looking for. If you want to obtain divorce records, you do not have to go through the Public Information Act. You can go to any county clerk's office and you can obtain them by using a computer that is located in the court's office. What you can't obtain and what you shouldn't have been able to obtain in that horrible case you heard about is restricted information. So information about the lady's children's names, dates of birth, financial information is already restricted under court rules for attorneys and participants, litigants in divorce and custody matters to file documents with the court. Furthermore, a person in her position, a public position, could file to seal the records. So this is why we believe that there's already appropriate statutory protections and that this bill is not adequate or necessary. Thank you.
Good afternoon, members of the committee. My name is Rebecca Snyder. I'm the Executive Director of the Maryland, Delaware, D.C. Press Association. We, too, are opposed to this bill, and it was a dreadful situation that brought this bill. But as my fellow panelist has noted, this bill is not necessary. There are privacy protections under current law. And I would also just urge us to think about what you give up when we sort of shrink back on this privacy protection. Privacy is important, and you are giving up the ability to understand the effects of the legal system, to understand what judges are doing in a sort of a macro level. You are unable then, the judicial system should be transparent, should be open, and the public should be able to know how judges are ruling. There are appropriate protections to shield information. A judge can seal and the clerk can seal information. And we give up the ability for the press to really look at the system as a whole. And so I would urge the committee to understand and look to a systems approach because you can always seal records and many things are already sealed. So we would urge an unfavorable report. Thank you.
Thank you very much. We have a couple questions from the committee. Delegate Wilson.
Thank you. As someone with a long and sordid history of divorces, I would be curious to know.
Are you talking about yourself or me?
Number one, what is your job title again, ma'am?
I'm sorry?
What is your job title?
I'm a lawyer. That's my title.
I thought you had an...
I'm here on behalf of the Maryland State Bar Association, the family law section.
And because I guess my primary question is, I know they can be sealed, but we heard a general from the press, the importance of systemic knowledge, but I was looking what other states kind of do this now or do something like this. What's the importance of my personal information? Because the goal here is to make it automatically sealed to where just not anybody can go and find out what happened during my last divorce. And from the bar's point of view, I just don't understand what's so important about that knowledge. I know things can happen, but the problem is a lot of people don't know that, or they find out later that they can. The sealing part, and I believe you have to file a motion. I don't do divorce law, thank goodness. And I just don't understand why it's so important that this information actually be public.
Okay, I think it depends on what you mean by personal information. When I look at the legislation as it stands right now, an application for divorce would be sealed. The financial record, which I believe is already restricted information under a different section, a record of a divorce settlement, and a custody order.
Right.
So I'm not sure.
But why, I mean, I'm sorry, just to clarify.
You go ahead.
Why does it matter if any of that's public? Why would I want anybody able to go back and look at any of my prior divorces? I don't understand what the public good of that is.
Okay, so there are bodies who sit in court, just as one small example, besides the press example, which I think is a huge one. There are groups that sit in court and listen to all manners of types of cases, including divorce cases, which sometimes involve domestic violence and things like that. And they are monitoring the judges. And they write reports, and they tally the information, and they provide the information in order to hold those judges accountable, or to ask this body or you as delegates to introduce new law, to sometimes train judges in a different way, sometimes train custody evaluators in a different way. If we took this step, I fear it would be the first step towards having to close and seal every divorce and custody courtroom. Because if all of this is privileged and private and cannot be released, then the whole hearing that is occurring regarding the information is going to be a closed hearing, like juvenile hearings, which, you know, the legislature and the court system have identified good reasons to protect juveniles. We are all adults and we have private information, that is for certain. But once we close those doors, I don't know how we reopen them again. And our whole system under Rule 16904A, in my written testimony, I refer to it, is about transparency. It's the whole basis of our society.
Oh, and I understand the judicial overwatch. I've been a trial attorney for 25 years. I do see the importance in that. I just think that what we're hearing and what I've heard and read previously was the amount of personal information that can be released can be damaging to the individual. So what you guys are discussing is a systemic issue versus the impact on the individual, which is, again, what we've done for juvenile cases. We realize that systemic benefit of not knowing that juvenile by name or seeing his picture posted or having those closed was important enough to protect. And I just, as a practitioner, I would think that you would kind of understand that this is some of the most, sensitive things that are discussed. And obviously people in the courtroom, I get your point, but that's to allow just anybody to look up my prior divorces. I mean, it is what it is at this point for me, but I can't see what the public benefit of that for my personal information to be so publicly broadcast in some of the most tumultuous times, because these individuals are also, going through it. I'm sure you know.
Yes.
And I just didn't understand what your pushback. So yours really has nothing to do with the individual. It's more of a systemic protections.
Yes, but I also want you to hear what I'm saying that you and I are in agreement with regard to your personal information. So if we wanted to have a talk offline about what that personal information is, and if the legislation tracked the same statutes that apply to the restriction of personal information in court documents, that would be a whole different ballgame. So
when they talk about the divorce settlement, there is indeed a lot of personal information, financial information as well, right?
Well, that should all be restricted. So if there is a settlement restricted under another set of laws, do you understand what I'm saying? That the PIA request is one avenue to get information about the court system, which these people use all the time. If you wanted to just get the divorce records, you could get what is considered to be a public record, which should not contain restricted information. So in my view, the Public Information Act should also not allow restricted information to be released.
But I believe it does. currently?
I don't know. So if it does, that's a fix. That is.
And you see, because that's what I'm looking at. I think there's a, I understand your point, but I just didn't, knowing, like they said, looking at the application of divorce, there's usually a rationale put on there, correct?
Say that again.
For the application of divorce, there's rationale. There's reasons. You have to give reasons for divorce, right?
Okay, well, yes, under the old law, those could be very personal and awful reasons.
Yeah.
Under new law, thank you, we don't have to say personal and bad things about our spouse. We can get divorced under irreconcilable differences.
True, but you know, as you're a divorce attorney, right?
Yes, I am.
That's not always what's done.
It's not always. You can throw in the other bad things too.
Right, that's what usually, I mean, I see that happening a lot with colleagues. I guess my concern is knowing what's out there and how personal it is or can be. It's just, I find it problematic because, again, I'm trying to figure out where the judicial overwatch is sacrificed. Are you worried about what's coming next? Or are you, because you're talking about now having sealed courtrooms, do you believe that this bill will force that? Or do you believe that that's the camel under the...
I believe it's a distinct possibility because the other areas that are restricted have closed courtrooms.
Right.
Yeah.
But those are also specified, correct? Aren't those closed courtrooms specified? Like those have to be closed courtrooms.
Right, but how do we restrict public access but have an open courtroom?
Because we're discussing records versus actually court proceedings. One is court proceedings that we're sitting through. Another one is the record of what happened and what's been agreed upon, the settlement that both parties agreed to. And I apologize for getting too deep, but I'm just trying to understand, because to me, I just don't see the public necessity to find out why, Melissa, when it happens, when they get a divorce, why everybody should be able to pull that up, possibly using it against her if she doesn't know or attorney doesn't know that they can seal it. I just don't get that, because I believe there are other ways to get empirical information on judicial rulings. And honestly, yeah, I'm just at a loss here because I'm trying to figure out why.
I don't know what that, I didn't want to interrupt you.
No, you're fine.
Just to follow that
We're
thought.
attorneys, this is what we do.
I don't know where else you would get the information.
From the individual?
To hold judges accountable, to have transparency in our court
And I guess that would go to a lot of times in criminal cases, I'll send them to the press, and
But they won't be able to get it either.
If I let them. This is something I can turn over. As an individual litigant, I can always turn over my reports. If I believe that something has been done wrong, I can always reach out to the press and say, hey, this is what we want. And I understand, Madam, from the press, I understand you guys, none of this works. I understand why you're, every step of the way you're going to fight it. I get that. Mm-hmm. I was just trying to find out what I was missing, because to me, this is some of the most personal information that can be put out in a courtroom.
I'll give you one other example. I have had to do this myself, and maybe you have too. If you're representing a client who is a parent, and the other parent, it's a custody matter involving a divorce case, and the other parent has now begun a relationship with somebody, you find out that somebody has a very serious background with their own children, that they lost custody of their own children for perhaps good or bad reasons. And so you, as an attorney for parent A, get the records of the divorce and custody matter of the new paramour. And that reveals a lot of information for you in the discovery process, and then you continue to do your due diligence. You don't just offer only that record, but that record is an important bit of evidence in your trial.
And so there's no exception for a subpoena. Like you're saying that if this bill passes as is, would it be more acceptable if this records would still be allowed to be subpoenaed?
It is authorized under, you do have that exception, authorized under a court order to inspect the record.
So you understand, like I said, that doesn't really solve, that really sounds like it solves your problem, because your due diligence, you would try to subpoena any and all prior information, I'm assuming.
If the subpoena is, so you wouldn't necessarily subpoena the court. You would have to go to a hearing and have a court order allowing the clerk to release it to you.
Right.
We're saying the same thing.
Right, yeah. We're saying the same thing. It sounds like that
You'd
problem
have to prove it.
right, that problem is solvable. If you believe that Paramore had issues with again, and mind you, these are all allegations. They have some other concerns.
Sure.
Many things that are alleged in these courts are never proven. Like child abuse is something that's always brought up. Even allegations of child sex abuse that are brought up during the proceedings, depending on the nature of the application and what's written there, that could be public record, even though it's never proven. Correct?
Absolutely.
And that's the way it is now.
Wait, what is
the way it is now is if there's an allegation, if my wife and I get a divorce and she alleges child abuse in her filing, that will be made public record for me.
If just the application for divorce.
Correct.
Just
Okay.
on its face.
So you understand my pushback?
Oh, I do. I completely understand you.
Thank you. Thank you, ma'am.
All right, thank you very much, Delegate. Delegate Fair?
Thank you, Madam Chair. And thank you both for being here. I have not tried divorce yet. Delegate Wilson keeps recommending I try it. I'm not sold. I'm not sold yet.
Gotta get the first one out of the way.
I also don't recommend it.
Yeah, fair enough. All right, I've got 2 votes now. All right, so I'm looking at this. I'm looking at the bill and what they're essentially suggesting. And your suggestion is that there's already all these protections in place currently existing in law. And in statute. And I think that there's a genuine disagreement that exists. But we can all agree that if this does actually exist in statute and does exist in law, that Ms. Gallagher's testimony shows that there was a infringement on her rights and that she was put in danger by an action of the state. Is that fair?
I have to say that I was in the hallway when she testified.
Yeah.
And because I think the bill was called out of order, which is fine. I'm glad I was here.
It wasn't.
No? Okay,
it wasn't.
great.
It was called an order.
Okay, perfect.
But that's okay.
My bad. So I can't really answer that. I'm sorry.
That's okay. No, I'm trying to grasp, because you said you called your friend in Anne Arundel County Clerk's office, and they said that if this information was released, including the children's names, that was improper from the clerk's office in the county of jurisdiction. Is that correct?
Right. The clerk of the court in Anne Arundel County is familiar with the story.
Right.
Yes.
And so my question is very simple. If we don't have this bill where we're looking at how to right what we all agree is an egregious wrong that was done against an individual, should we edit this bill to make stiff criminal penalties against our clerk's office when they take action like this?
No, I don't think so.
Well, do you think that it's fair that Ms. Gallagher was put in a life-threatening situation because of an administrative accident?
No, I don't.
Okay, well then what do you think is a reasonable response to somebody having their life threatened and their children's lives threatened? What do you think is the reasonable response to that?
Well, I think she perhaps would have an avenue of criminal penalties against the bad actor, not the clerk.
So the clerk bears no responsibility for releasing that information
I also did not say that.
Okay.
First of all, I do not have any direct knowledge of whether the clerk made an error under the PIA or whether the clerk was proceeding under just, these are court records, so here you have them, and then they didn't redact or restrict what they were supposed to restrict. I have no personal knowledge of it.
Sure.
So I really think that's my answer.
But we're sitting here, and I'll just end on this idea. We're sitting here today hearing of either one of 2 things that happened. A policy and a law was not followed by the state, and it was not administered properly, or we have a massive deficiency that allows the public, the general public, without any interest in this case, to be able to obtain all kinds of personal and sensitive information of any Marylander that they want. And that's really what public policy is all about. I think we all agree that that's usually designed to help fill gaps. So for me, I'm just looking at this bill and saying, we take this method, or we look at the alternative method, which is what happened to this individual. Should we look at strengthening our laws to make sure that folks that are releasing this information are held more accountable? And so that's kind of my perspective of where I'm thinking. But I'll leave my thoughts there, Madam Chair. Thank you.
Thank you very much. Delegate Schindler? Oh, sorry. Okay. Delegate Sample Hughes.
Sure. Thank you. Thank you, Madam Chair. I did have a question for you. You had mentioned that there were groups that monitor judges' decisions, behaviors, et cetera, are they affiliated with the Commission on Judicial Disabilities? Is that part of their work product?
I'm not sure if they send people in to watch court or not. I don't know the answer to that. When I was referring to a particular group, in my experience, this is my personal experience, I've been a litigator 30-some years. For a long time, I was a prosecutor, and now I have been a family law attorney for also a long time. I was aware of particular domestic violence groups coming in to watch judges, to monitor how they were responding in particular cases that involved those issues.
Okay, so you're specifically referring to a domestic violence group, but not any groups that you're aware of or affiliated with the Commission on Judicial Disabilities to monitor judges' behavior?
No, I'm not aware of that.
Okay. And then my second question, just for clarity, I'm not a lawyer, but I do understand where my colleague is coming from in cases such as this. You mean it's enough business out here, people's personal business on the streets and everywhere. And so I think that's just over the top. But I did want to just ask for my knowledge, who specifically can ask for sealed records? You had mentioned that.
Say that one more time, I'm so sorry.
The seal, you said they could file, someone could file to seal the documents?
Yes.
Who are they? I don't know, I'm not a lawyer.
Oh, the party.
Either one of the individuals that's involved?
Yes.
And no one else can do that, correct?
I'd have to look at that law. I don't have it right in front of me. There could be some additional avenues. I think the court can do it on its own initiative. The court usually can. Yeah, she's saying the court, she's agreeing with that part. I'd have to look at that law, but whether there was, a guardian or a second friend of a child or some, a best interest attorney, perhaps.
Yeah, if you could find out, that'd be great.
Sure.
So we'll just know while we're making our decision in subcommittee.
Yes.
Okay, thank you so much.
I'll send you that law.
Thank you. That's all I have, Madam Chair.
Thank you so much. All right, seeing no more questions, I just want to call for one more time Mr. Otis Bill Watabi Wifdren. I don't know if he's in the room with me or with us. Okay, seeing that, this concludes the bill hearing for HB 403.
Thank you.
Thank you for your testimony. Thank you. Thank you for the bill. We'll move on to HB 649, the Department of Civil Rights Commission. Have on the first panel, Spencer Dove, Cleveland Horton, Lindora Hughes, and Monique Dixon. All right. You may begin.
Good afternoon, Madam Chair, Mr. Vice Chair, members of the House Government, Labor, and Elections Committee. The Maryland Commission on Civil Rights would first like to thank the committee for its continued engagement and consideration of House Bill 649. For me, I think it's important to first just give part of the impotence for this particular legislation. For me, back in 2015, 2016, I became aware of issues involving a number of minority students who were recruited and were provided admission to a private school here in the state of Maryland. The school was a predominantly white institution. The students were eager and excited about the new opportunity to attend this particular private school. In full transparency, one of these students is my son, so it's not hearsay for me, it is direct knowledge of the issues involving these students. From the first day of admission to this school, the students were followed around with cameras by the white students because they look different. The white female students repeatedly told them, do not speak to us. If you do, we will tell the administration that you tried to touch us. These students were isolated, forced to deal with a number of particular issues regarding race relations within the private school. There was an incident between one of the black male students and one of the white female students in which all of the students were called down to the office with no parental notification, supervision. The black students were interrogated by the state police. Their cell phones were confiscated. The white students had the opportunity to have their parents notified, their parents' involvement. The black students were not. I were one of the parents who sat outside in the parking lot waiting for my child to come outside, as I normally do, to pick him up from school, and it took him about an hour to come out. When he came out of the school, that's when I was notified that he was sitting in interrogation with the state police. He could not return my text messages, obviously, because his cell phone was confiscated by state police. He had no direct knowledge or involvement in the activity. He just happened to be one of the black students that fit the description because of he was guilty by affiliation. We reached out to the school, a number of the other parents of the black students, to inquire about the issues that our students were facing. The school's response was, well, your kids need to isolate themselves and be more friendly with the other students. So we had no follow-up. As the executive director of the Maryland Commission on Civil Rights, during that time I was the deputy director. You can imagine I do fancy myself a change agent, a civil rights leader here in the work, but my hands were tied. There was no state avenue for us to enforce or address the issues that these students were facing day in, day out. So I began to have conversations with other, particularly minority parents, to see if they were encountering the same thing with their kids in other private schools. Unfortunately, they were. So for many of the schools that we do face, many of our students, especially minority students, are suffering in silence. The ideal that you can go to school and be safe, go to school and get an education, go to school and be treated like any of the other students, unfortunately for many of our minority students, is just not the case. So we began to figure out as an agency, what were some of the things that we could do to address some of the issues that we see within our educational system. We began to have conversations about posing legislation and what that would look like and how we would craft it. So here we are now, 10 years later, House Bill 649. I do want to thank Monique Dixon, who was here on the panel with us, who played a critical and important role in helping us craft the bill that you all see before you all. I do want to ensure that folks understand that this bill addresses state-level enforcement gap in education discrimination, particularly in higher education. This bill is not intended to replace the Office of Civil Rights, but again, to provide a state-level parallel safeguard and to reduce the over-reliance on the federal capacity. Many of us do understand the current climate within the federal administration, that there's no longer the dependence that we used to have on the federal government to be able to address these issues through the Office of Civil Rights. And we want to ensure that our students are not impacted by that current condition. While Federal Office of Civil Rights remains operational, the record does show they do have a growing complaint value and they do have documented backlog and delays. Maryland students currently lack a comprehensive state-based civil rights enforcement option comparable to what we see in our employment, housing, and public accommodations area, where there is also a state enforcement mechanism for folks to file discrimination complaints. House Bill 649 is about ensuring Maryland students are not dependent on the capacity or the stability of federal enforcement to vindicate their civil rights. And when we think about enforcement authority, our enforcement authority model is well established and bound by state and case law. Our agency has nearly over 6 decades of experience implementing remedies that are proportionate, targeted, and subject to administrative and judicial review. House Bill 649 does not create any level of unchecked authority. Our authority is not open-ended. It is structured, reviewable, and grounded in long-standing Maryland practice. While we appreciate some of the conversations that we've had with individuals regarding this bill, we know there's a conversation around our capacity to be able to address these types of issues or our staffing. But I want to say that we are approaching implementation of this responsibly. We've delayed the effective date, we have regulatory development period, and we have ongoing stakeholder consultation. The complaint volume will be monitored closely. We do believe that with the additional staff that the administration granted our agency last year, which allowed our agency to increase by 30%, we do have the staffing needed to support this bill. We already investigate complex discrimination claims across multiple sectors. We will promulgate education-specific regulations, engage subject matter experts, and coordinate with the Maryland State Department of Education and higher education partners to ensure consistency across this regulation. House Bill 649 does not displace Title IX processes. Institutions still must comply with federal law. This bill adds protections. It does not subtract federal obligations or institutional expertise. Our current enforcement system already manages administrative investigations, election of civil action procedures, and coordination with courts. House Bill 649 mirrors existing functioning civil rights enforcement models already in existence here in our great state. At its core, House Bill 649 is about making sure that when Maryland students experience discrimination, there is a clear, reliable, and timely place to turn at the state level. We do see this House Bill 649 as our effort, our responsibility, and our obligation to protect one of our most vulnerable populations, our students. NCCR respectfully requests and urges a favorable with amendments report on House Bill 649.
Good afternoon. My name is Glendora Hughes, and I'm General Counsel for the Maryland Commission on Civil Rights. Mr. Horton has presented the agency's position regarding House Bill 649. I'm here to answer any questions that may come up concerning the bill.
Good afternoon, members of the committee. My name is Spencer Dove. I'm the Special Assistant to the Executive Director here at the Commission on Civil Rights. And like our General Counsel, I'm here to answer any questions by way of testimony. I offer a hearty me too to the comments of the Executive Director. And in reviewing the fiscal note that was available online this morning, I did just want to highlight one of the remarks on page 8, DLS's note, and really underscore this. The responsibilities for educational institutions are largely unchanged by this bill, as are the prohibitions against discrimination based on certain protected classes. In our testimony, I have made sure that it includes a briefer on the amendments that we have put forward as the sponsoring agency. We negotiated these amendments with stakeholders, including the State Department of Education, and we think that they all make the bill infinitely better. So thank you for your time and consideration. And with that, I will turn it over.
Good afternoon. My name is Monique Dixon. I am the Executive Director of the Gibson Bank Center for Race and the Law at Maryland Carey Law. We appreciate the opportunity to provide both written and oral testimony in support of House Bill 649, which will expand protections from education discrimination. We urge the committee to issue a favorable with amendments report. In addition to the changes offered by the commission, we respectfully request an amendment that would allow students to file a civil action in state court as soon as the law becomes effective, rather than 30 days after the commission issues regulations. Students should not have to wait to enforce a law created to protect them. Quote, today, education is perhaps the most important function of state and local governments. Such an opportunity where the state has undertaken to provide it is a right which must be made available to all on equal terms, end quote. Brown versus Board of Education. When Brown was decided, Maryland had maintained racially segregated schools for generations. When Maryland and other states refused to follow Brown's mandate to desegregate schools, Congress passed non-discrimination laws to protect students. Yet allegations of discrimination in Maryland schools have persisted. As of January 2025, more than 270 open investigations of discrimination complaints and allegations against Maryland schools were pending at the U.S. Department of Education Office for Civil Rights. House Bill 649 will help address allegations of racial discrimination and other forms of discrimination by Maryland schools at a time when the federal government is unable or unwilling to do so. It is time for Maryland to take the lead in protecting students from discrimination. We urge a favorable with amendments report. Thank you.
Thank you very much. Delegate Fisher, okay.
Disheveled over here. So how many, first of all, thank you for the testimony. How many complaints did you say were there that have been made in Maryland for discrimination?
According to the U.S. Education Department's Office for Civil Rights, there are 271 allegations.
In Maryland?
from Maryland.
Okay.
As of the January.
And how many to your departments or to the state itself?
Well, presently, we don't have jurisdiction, so we don't receive those complaints.
Okay. Do you ever, and I mean this sincerely because I've always found it to be remarkable that in Baltimore, where I'm from, but I represent Calvert County now, that we have a situation where 84% of 8th graders are illiterate. Do you guys ever get involved in that to find out why 84% of the children, even though we have record spending in Maryland, some of the highest in the world, aren't learning? Because to me, since most of the children in Baltimore City, certainly not all, but most are black, to me that's a crime against this generation. And I'm not sure why there's so much silence on that issue. I'm not saying that you're silent. I'm just asking the question, try to have the conversation.
No, we respect your question and understand your concern, which is many of us are concerned. That specific area is something that it would be under the auspice of the Department of Education. What we are attempting to do here with this bill that may intersect with some of those issues that you're raising is to provide us with jurisdiction to conduct investigations on issues that are discriminatory, that do impede the opportunity for students to get education and have the same rights as all other students do. And that is the intent of what we're trying to do here, is to provide an ability to have oversight, to look at the complaints from students and from their parents as to why their education experience or opportunity is being impeded in a discriminatory fashion.
And I appreciate the answer. I mean, I would love it if the bill were strengthened to give you the authority to sue, because by sue, I mean sue when you don't have children learning. I'm talking about children that are perfectly capable, not special needs children. I'm talking about children that are perfectly capable of learning but aren't learning, and for whatever reason end up graduating illiterate. To me, that would be, I appreciate it, Madam Chairwoman, this would be a really wonderful, wonderful addition to your services, because the numbers that we're seeing are third world numbers out of the third world, and it should not be that way. And it was never that way when I was growing up. And I'm passionate about the issue, just so you know, because I went to a really crummy high school. It was terrible, terrible. So it just doesn't seem to be getting better. So, but thank you.
Thank you.
Thank you for your comments.
Thank you. I had a question. I guess Delegate Fisher kind of prompted me to think about this, but if we were to this is going to require us to go back into history a little bit, but just thinking about the questions, valid points being raised and questions there, but also with what this bill is seeking. So we know historically Baltimore City Public Schools were underfunded, and there was a lawsuit by the state many years ago. So would this have if say this existed within the commission, would this enable what this bill is enabling to do, had that existed 40 years ago, would that have provided recourse for a lawsuit on those grounds for discriminatory school funding practices? Would that have been something that could have been brought under, if it had existed, right? If this existed, would that have been able to be brought under what you're seeking to do here?
It potentially, because what you're speaking about is what we call discriminatory or disparate impact, that the policies are neutral, but it has a disproportionate impact on a particular minority or particular protected class. A part of the bill is to provide the option of a civil litigation, which could be brought by the students in a systemic type of suit that could be bought by one of the organizations that represent students, or the commission could issue a commission complaint and file a systemic claim dealing with a systemic problem. The idea of a systemic litigation is not just to resolve what is the issue or the discrimination of the individual, but to change the systems or the policy that is causing the impact on that student and other students or like groups of people in that situation. So those were potential options that would have been available if they're providing, and that's the purpose. We're not trying to reinvent the wheel and create something new. We're trying to enhance and improve what exists in the Department of Education and provide coverage that doesn't exist in higher ed for students that are being discriminated against in those universes.
Okay.
And provide a process where there is that alternative option available.
Thank you. Delegate Schmidt?
Thank you, Madam Chair, and thank you all for being here today. Mr. Horton, I have just a quick question and a follow-up, if that's okay, Madam Chair. In your example, was your child in a high school or in a college? Because I didn't, it was in a high school, okay. Because I thought you had told the story, it sounded like high school, basically when you talked about the office and things like that. Now, is there any other mechanisms that we have currently in place that would help in situations like this? Any previous laws that we may or may not be aware of that the State Department of Education may have?
What is available is if an institution receives state funds, they may be covered under the Department of Education's article, and which there could be a complaint filed and an investigation. They don't investigate, there will be an attempt to mediate and resolve the issue that as a remedy for the Discriminatory Act. But those institutions that do not receive state funds, nor is there capacity to conduct an investigation under the present article, there is no oversight. So what happened at that private school and others, or basically there is no option available to the persons that, the students or their families that suffer the discriminatory action for them to file anything.
Just a quick follow-up. That's okay. And does the Maryland State Education Association have any oversight over any of that, or is that all just public schools?
The Maryland State Department of Education, the superintendent and their board, they have oversights over secondary, primary, secondary, up to K through 12. There is no oversight for higher ed. And their oversight is to, as far as non-public schools, is if they receive state funds.
So
that's the extent of.
They would do that through the Department of Education then?
Yeah.
I understand. Thank you.
Delegate Crutchfield?
Thank you, Madam Chair. And thank you for being here and having the courage to bring forward a bill like this. I just wanted to talk about a couple of things. One is your jurisdiction. Isn't it true that your jurisdiction is the Maryland Civil Rights Act as promulgated from the Civil Rights Act of 1964?
Our jurisdiction in state government article Title 20. We track some of the provisions that are in Title VII on the federal side. We also have we have a housing component, so we track fair housing discrimination, Title VIII. We also have public accommodations, which tracks the public accommodations law on the federal side. It's not verbatim. There are things that the General Assembly has added or expanded. Under state law, we can have broader coverage, but not less coverage than federal law. So there is no preemption as long as we are not less than what is provided on the federal level. However, as we see, the implementation and the current enforcement is now changed. And that was one of the things that led us to look at, well, how do we protect Maryland students in the area of education when we're now at, they're basically at the mercy of what's happening on the federal level, and we want to say, well, we no longer need to be at the mercy of the federal level. And we have done that in other parts of our statute where the General Assembly has passed or codified in our law things that no longer are being enforced, that were not being enforced on the federal level, but are now being enforced in Maryland as far as housing and employment in other areas.
Okay, so isn't it so that you need to increase or change your jurisdiction in order to provide for the protection of children that are in the schools?
Yes, and that's the purpose of this bill, HB 649, because we don't have that jurisdiction presently.
Thank you.
Thank you.
Okay, thank you very much. Seeing no more questions for this panel, we have, oh wait. Thomason, you're at least once a week, man. You're always sneaking in there. I'm happy to call on you, Thomason.
Sorry, I'm a little slow.
Delegate Thomason.
A little slow over here.
Okay.
Thank you, Madam Chair. Just kind of piggyback off what Delegate Schmidt was asking. He was asking about, I just want to follow up with what he was saying. There was a school non-discrimination bill passed in 22, I think it was, that that might have kind of addressed some of these issues. And are there, my question, I guess, to you is, does that bill, if you're familiar with that bill, does that help with anything you guys are working on? And then are there any regulations in place already with MSDE, with filing complaints? Have you pursued those paths already?
I believe that bill provided the Maryland State Department of Ed the authority to receive discrimination complaints in 22. And it does, but there is a limit to what they do not investigate. They receive the complaints and their attempt to mediate and resolve it by referring it to the Office of Administrative Hearings for mediations. And if that's not resolved there, they write a decision. And then the remedy is the addressed through the removal or the suspension of state funding of that institution that's in violation. There isn't any, in terms of the individual receiving relief, there isn't any investigation. They don't have investigative ability. So one of the things is we're not replacing that will still be an option that's available to them. What we are looking in terms of being systemically equal to what is OCR is the option that they send Marylanders to file with OCR if it's not handled by the Department of Ed. And because of the state of OCR, which if you, in our testimony, offices have been closed, people have been fired, cases are piling up or not even moving, that we sought to step in that gap and provide Maryland students an option of where they, in lieu of OCR, they can be have the protection under state law and have an ability to have their complaint redressed under state law.
And Delegate, if I may add to that as well, that law, that program is one of the reasons why we did engage with the State Department of Education. We leaned on their experience, their expertise. They helped to inform our sponsor amendments that we've submitted for this bill, and that's ultimately why we drafted the bill to have concurrent jurisdiction with the State Department of Education. So we're really complementing the solution that they offer within state law, and then we start filling in those gaps where, as Ms. Hughes has said, that they currently cannot take any complaints alleging discrimination.
Delegate Stewart.
Thank you, Madam Chair. Thank you all for coming. Thanks for the bill. I came in a little bit late. I had to do a jointly assigned bill in a different committee, so y'all may have already covered this. But what is exactly the liability standard under the bill? Is it intentionality? Is it reckless indifference? Is it negligence? I couldn't find one. I know that the federal laws have certain standards laid out. This one is, it seems to be the bill text is silent on that, but correct me if I'm wrong.
In terms of when we investigate and handle discrimination cases, we we will process them like under the theories that exist, like differential treatment. And I think there is language in the law that indicates the disparate impact theory, which I explained earlier, where there is a policy in place, not intentional, but the impact on a certain group of people because of their protected class is to their detriment, where you have policies that neutrally, but for instance, discipline, but unfortunately, the number of persons that are being suspended are all of one protected class or the majority protected class. So there is basically what we call direct evidence that the smoking gun, that there is just direct evidence that discrimination, blatant discrimination did take place. And we investigate under these legal theories in assessing whether or not there's, in terms of a complaint coming to commission, whether there's probable cause that there was a discriminatory action taken or no probable cause that there was no discriminatory action taken. And then we would attempt to resolve those before an investigation is completed and after. Mediation and settlement are built into our system.
Okay, that makes sense. And you may have already covered this, and maybe this is in the amendments too, but what is the rationale for ending the commission and ending the administrative process once someone files a suit in circuit court?
So that it's done so that the person is, the cases are not in multiple forums.
Okay.
So that the school or the institution is not trying to defend with the administrative process and the in court as well. And we have that same requirement or in legislation in our employment and housing, pick your forum. You can't have multiple forums so that everybody is confused and running to different forums trying to defend the very same set of facts and the very same complaint.
Just one more question, Madam Chair. Is there an administrative exhaustion requirement under either this bill or in any of the other any other issues you guys?
We have administrative exhaustion under our other employment and housing. This particular bill doesn't have the administrative exhaustion.
Okay. Thank you all so much.
Thank you.
Thank you. Delegate Chisholm.
Thank you, Madam Chair. If we pass this bill, would it then increase your jurisdiction over private religious schools as well?
Yes, it would, but there is an exemption in there in terms of religious, what it says, this subtitle does not apply to. There are a certain exemptions, religious institutions as defined in the exemption area. But it would apply to non-public schools that potentially that are not presently covered under this.
Okay, thank you. Thank you, Madam Chair.
Thank you very much. Okay, seeing no more questions from the committee for this panel, thank you to the panel. Thank you for presenting the bill. We will move to our second panel. We have Frank Patinella, Shalimar Douglas, Megan Berger, and Ingrid Lofgren. And we have Sabrina Bernadelle. I think we are running out of chairs. Hi. Okay, she's virtual. Thank you.
Okay.
All right, Mr.
Good
Patinelli.
afternoon, Madam Chair. Vice Chair and members of the committee, my name is Frank Patinella. I'm a senior policy advocate for the ACLU of Maryland, and we strongly support House Bill 649. First, I want to acknowledge and honor the civil rights leaders of the past who dedicated their lives to pass laws to protect the basic humanity of Black and brown children and others who were traditionally marginalized in our schools. The Office of Civil Rights began taking complaints in 1967, and today it has become the go-to destination, the last best hope for families seeking justice and relief when efforts fail at the local and state levels. As we're all seeing now, this longstanding cornerstone of education justice is being dismantled. More than 50% of the staff at USDE were laid off, and many more chose to leave. And I've seen reports that up to 90% of the civil rights staff are no longer there. Between March 2025 and September 2025 of last year, OCR, Office of Civil Rights, received nearly 9,300 complaints just in that 7-month period. The office dismissed an astonishing 90% of them, likely without any investigation at all. Most of these complaints alleged race, disability, or gender-related discrimination. The report poses that the Office of Civil Rights is systematically refusing to investigate civil rights cases serving marginalized populations. Instead, the office is using its resources to target higher ed institutions to dismantle DEI programs throughout the country. And it's not just those at the top in power causing this harm. Perhaps actions and behaviors modeled by those in power are trickling down. We are seeing an increasing number of reports of discrimination in our schools related to gender identity, disability, and race over the past year. My organization is seeing an uptick in education-related discrimination complaints. We're aware that MSDE takes discrimination complaints, but we also know that MSDE is overstretched and that there needs to be an independent entity out there looking out for the kids. Last sentence, if this committee is alarmed, as we are, about the ongoing attacks on marginalized communities, then we need to double down on our commitment to our Constitution and civil rights. Thanks.
Okay, so it's afternoon. Good afternoon, Chair Wells and committee. I'm Charlotte Douglas. I am with the Maryland Alliance for Racial Equity and Education, MARI, a coalition of education advocates, civil rights, and community-based organizations committed to eliminating racial disparities in Maryland's education system. We offer a favorable testimony for House Bill 649. I speak today centering Black students, families, and communities across the state who have long relied on federal civil rights protections to ensure their children can learn, grow, and thrive free from discrimination. At the moment when the federal government has repeatedly failed to uphold that promise, Maryland must act. The U.S. Department of Education's Office of Civil Rights has historically served as the primary enforcement arm for Title VI of the Civil Rights Act of 1964. For Black students and families, the Office of Civil Rights was often the only avenue for recourse when schools failed them. For Black students and families, these protections are not abstract. They address real documented harms that occur in Maryland's classrooms and on Maryland's campuses: racially disproportionate school discipline and exclusionary practices, denial of access to gifted and advanced academic programs, discriminatory harassment and hostile school climates, and inequitable resource and distribution that has historically disadvantaged majority Black school communities. Maryland has a Constitution and moral obligation to ensure that no child is denied an equal education on the basis of race, disability, or any other protected characteristic. The blueprint for Maryland's future, passed in 2021, represents a generational commitment to closing opportunity gaps and investing in historically underserved students. HB 649 is the necessary civil rights infrastructure that makes the commitment enforceable and durable. A blueprint without civil rights protection is a promise without teeth.
Good afternoon, members of the committee. My name is Megan Berger. I'm the legal director at Disability Rights Maryland, a nonprofit law firm, and the federally designated protection and advocacy agency. We're mandated to protect the civil rights of individuals with disabilities. Disability Rights Maryland strongly supports HB 649 because it strengthens civil rights protections for Maryland students and fills a critical gap in civil rights enforcements. It protects students from intentional discrimination and from practices or policies that have an unjustified discriminatory impact. We do support the bill with favorable amendments that I have shared with the sponsor. Our several technical amendments are detailed and outlined in our written testimony, and I'm happy to answer questions. DRM is excited about this bill because it builds a strong and resilient civil rights infrastructure in Maryland so that students and families can look to their own state for protection against discrimination. For decades, Maryland students and families have accessed and relied on federal anti-discrimination statutes and enforcement mechanisms to protect them. Now, however, there's been the undercut, given the dismantling of the Department of Education's Office for Civil Rights, and OCR's ability to enforce has been hallowed, and this bill fills the gap. However, even more important than filling the gap, this bill creates a lasting civil rights infrastructure in Maryland. DRM's several technical amendments are offered for the purpose of clarity and to ensure that all students with disabilities, over 110,000 in Maryland, are equally protected by this bill from discrimination. Maryland has a unique opportunity to be a leader in building its state civil rights infrastructure, and we're urging a favorable report with the suggested amendments. Thank you.
Good afternoon. My name is Ingrid Lofgren, and I am the managing attorney for the Education Stability Project at the Public Justice Center, a nonprofit civil rights and anti-poverty law firm, and also testifying on behalf of the Maryland Coalition to Reform School Discipline. We are in strong support of House Bill 649 as a lifelong Marylander who came up through our state's public schools and institutions of higher education, as a parent of children in our state's public schools, and an advocate alongside students and parents who are trying to access equal educational opportunities. I commend the Commission on Civil Rights for their leadership and their collaboration with the State Department of Education. The fundamental right to education is enshrined in our state constitution. This is core to our values and identity as a state. And as my colleague testified, we are living this out through the blueprint for Maryland's future. Student civil rights and effective enforcement of those civil rights are foundational to this promise. HB 649 is carefully tailored to address both the gaps in our current education anti-discrimination law passed in 2022 and to address the abdication of civil rights enforcement at the Maryland level, both of which leave Maryland students unprotected. Maryland is the first line of defense for Maryland students. We have long relied on federal rights and federal enforcement of those rights to be the backstop for our children and families. And while we hope and trust that that backstop will eventually be rebuilt, our students and families cannot wait, and federal rights and enforcement should never be the ceiling for our children. They are the floor that we build on, as we have in so many other areas, as the Commission has already testified. We know that other states are taking the same action. You'll hear more about that from our colleagues at the National Center for Youth Law, and we urge you to issue a favorable report.
Thank you very much. We have one virtual, and then but I will call you first, Delegate Fisher. We have one virtual witness with us, Ms. Sabrina Bernadelle. You have 2 minutes. Good afternoon.
Good afternoon. Thank you, Madam Chair, Mr. Vice Chair, and the esteemed members of the committee for the opportunity to testify in support of House Bill 649. My name is Sabrina Bernadelle. I'm the manager of the Education Civil Rights Alliance, testifying on behalf of the National Center for Youth Law, or NCYL, and as an invested Maryland resident and new parent. NCYL and our peer organizations at the national level are deeply alarmed at the federal government's abandonment of civil rights enforcement. Last year, the U.S. Department of Education's Office for Civil Rights terminated almost half its staff and closed 7 of its 12 regional enforcement offices, leaving the remaining staff with an over 400% increase in caseload and a backlog of over 25,000 complaints. As a result, they are unable to meaningfully investigate student civil rights claims. The Metro D.C. regional office that serves Maryland students had to absorb the caseloads from the Northeast and New England offices that were shuttered. To the extent that OCR is functioning, available data show that it is not protecting students targeted for discrimination, but rather appears to be focused on advancing a political agenda. We urge the committee to amend HB 649 to remove the 30-day restriction on bringing a civil action after the Commission on Civil Rights adopts initial regulations, Some students and families are in urgent need of access to remedies for discrimination that only a court can offer. Students cannot afford to wait years while OCR rebuilds. HB 649 ensures Maryland joins states across the country acting now to strengthen state-level infrastructure for enforcing civil rights, filling the gap left by the federal government, and building the protections its students deserve. I encourage the committee to review Nichols' written testimony for a more detailed analysis. We commend the committee for its consideration of HB 649 and respectfully urge it to issue the bill a favorable with amendments report.
Thank you very much for your testimony. Delegate Fisher.
We're back. Thank you for your testimony. Thank you, Madam Chairwoman. So I'm going to kind of go down similar questioning, but maybe not exactly the same. And that is, everybody agrees that education is important, and believe me, I'm right there with you, especially in the age of AI, where it's needed now more than ever to understand how things are changing. My question is, for anyone that wants to answer really, is I understand the bill, I've read the bill, but for years now, not recently, but for years, Baltimore City has 84% of its students in 8th grade who are illiterate. And we just got a new statistic that 1 out of every 5 students in Baltimore City drops out of high school. So understanding this, like why are you all focusing on that as well? And I would just add that Thornton was passed almost 25 years ago, the Thornton Commission, which recognized that funding had to be fixed. And so for 25 years, the funding has been record funding, and yet, it has. It's the 13th highest funded in the country and one of the highest funded in the world. So rather than going down the money side, let's go down how that's possible that 84% of 8th graders are illiterate.
I think I would love to have a conversation with you sometime after this hearing or perhaps after session. It's a much larger question, and it's not related directly to this bill. Regarding the Thornton Commission and then later the Kerwin Commission, we were very much at the core of those conversations. The Thornton Commission recommendations were not adopted, not in its pure form. There were a lot of compromises made. The legislature cut the Thornton funding in 2008, which led to a compounding impact of funding and the compromising of what was determined to be adequate funding. The Kerwin Commission delayed its report for many years. The legislature took a while to deliberate on that. By that time, inflation has set in, right? The cost of education all goes up. So, our position has been that the blueprint was never funded adequately in the law, according to, what the experts said that the per pupil funding should be. That's one part of it, but there are other aspects of education too that are lacking that need to be addressed.
So if we're spending...
Can I respond to your first question?
Of course. Yeah.
Sure. I'm Charlamar again, and I am a former educator, and I'm a student who went to Baltimore City Public Schools. I still know all of my teachers' names. I know my school mottos. I know my school everything. So I'm going to tell you, I went to Walter P. Carter School 134 for elementary. I went to Hamilton Middle School for middle, and I graduated from Western High School, the oldest all-girls public high school in the nation, and I taught for 15 years. And so I sit in this seat as an advocate and a policy analyst for education centering Black and brown students. And I hear what you're saying about literacy, and that's what our alliance does. The Maryland Alliance for Racial Equity in Education, one of our advocacy pieces that we are working on is literacy. And we are bringing that before the State Department of Education. We have deep concern about that. And in math. So the Maryland State Department of Education passed a literacy policy 2 years ago and now is open for public comment regarding the adolescent literacy policy. We've been very involved in making public comment and calling out those things that we need in our policies so that these gaps that persist with our Black students in public education are closed. We have the answers. We need systems to do what they have to do with regard to teacher preparation, with regard to discrimination, cultural proficiency to happen in our schools.
Delegate Fisher, if I may just chime in from the virtual space.
I would like
Actually, I'm so sorry. Hold on one second. I think we're gonna, Ms. Bernadette, if we're gonna, there's another follow-up question, so maybe you could respond after the second one.
My questions are really to the panel, so I'm sorry about that. And I appreciate, first of all, I appreciate that you're a teacher and that you grew up in the school system. But the fact still remains, and I'm just curious, it's like, well, how many generations do we lose of children, right? And I am on this bill because it gets a little difficult, I think, for folks here to say, well, let's continue spending $23,000 per student, one of the highest in the civilized world, and yet have these results year after year. In fact, the results are getting worse. So why not try something different? Like, why not shake the system up? Because to me, it sure seems like we have a monopoly, and the monopoly isn't working. And every county is different, okay? You know, if you include the 23 counties in Baltimore City, every place is different in the way you educate kids. I get that. Every kid is different. But why not try something different?
I agree with that last statement. Yeah, I think, and like I said, I think we'd all love to speak to you after the session.
Thank you.
I do want to say that record funding doesn't mean adequate. And I also want to say that, you know, the $23,000 per pupil amount is probably similar to a lot of the private schools' tuition, say Gilman, Calvert Hall. I went to Calvert Hall, and I know the population of Calvert Hall, right? It's mostly families that have a lot of resources, right, that are well connected. They're not educating a population of students that are similar to what you see in Baltimore City, right? The historic discrimination, the historic oppression in those cities, in the city, in those communities, the isolation. There's a lot there to unpack.
No, and lastly, thank you, Mr. Chairman. I appreciate it, but I would just say lastly, if Calvert Hall is $23,000 or Gilman is $20,000, and I don't know what they cost. I don't know.
It's way more.
Growing up in Baltimore, I know I couldn't afford it. My parents couldn't afford it. But the fact of the matter is there are kids in the system who are in K-12 who could benefit from that if the money followed the student. And there are other children who need different, every child's different, I understand that. But you equalize the system, if that's really the goal, by having the money follow the child. And the parent and the child chooses the best system for their child, as opposed to the one that's clearly failed. Not failing, failed. Thank you.
Seeing no more questions for this panel, thank you. We do have one unfavorable witness, Jonathan Alexander.
Mr. Chair and members of the committee, my name is Jonathan Alexander. I'm an attorney and legislative counsel for the Maryland Family Institute in opposition to HB 649, representing the families and schools that have relied on Maryland's carefully balanced education non-discrimination framework since its comprehensive revision in 2022. Since that revision, there has been no showing of systemic failure, widespread abuse, or an outcry of unmet needs that would justify upending that revision after such a short period. But now, since this civil liability model that was rejected Now that that's back on the table, all this does do is threaten the constitutionality of the framework in general. You know, the Supreme Court has made clear that states may not force religious schools to choose between public benefits and their faith-based practices. Consistent lines of cases say that. School can't be excluded from a general available public benefit. Parents can't be denied a state scholarship. State cannot exclude schools that provide religious instruction. And right here in Maryland, we had a case that said a federal court held that the state violated the free exercise clause of the school because of its religious beliefs. In these instances where the benefits were contingent on the institution forsaking its religious tenets, the religious tenets win out. When there is an issue that may arise between a religious tenet and any of the categories that are defined in the non-discrimination portions, MSDE has been not just competent in doing the work, but the argument was so thoroughly made in 2022 as to why they should and could be the sole mediators of the conflict. So because the workability of the law as it stands has been tested, because this new addition is fraught with religious liberty and constitutional pitfalls, I strongly urge a rejection of this bill. Happy to answer any questions.
Questions for this witness? Seeing none, thank you, Mr. Alexander. This concludes the bill hearing on House Bill 649. Delegate Palakovic-Carr, thank you so much for your patience. Please come forward.
Thank you, Mr. Chair. Good afternoon. For the record, I'm Delegate Julie Palakovic-Carr, here to present House Bill 549. This bill will modernize Maryland's ethics laws. As we all know, state elected officials, certain senior state employees, and candidates for state office must file an annual financial disclosure form. We self-report about our employment, our real estate holdings, the businesses we own, stock ownership, debts, and gifts we receive. This bill would make two additive changes. One, to require the self-reporting of cryptocurrency assets, and two, to add reporting about the finances of a domestic partner wherever reporting on a spouse is already required. Colleagues, our predecessors did an elegant job articulating the rationale for Maryland's current ethics laws and financial disclosure requirements. So I'd actually like to start by reading a passage from the General Provisions article. Quote, the General Assembly of Maryland, recognizing that our system of representative government is dependent on maintaining the highest trust by the people in their government officials and employees, finds and declares that the people have a right to be assured that the impartiality and independent judgment of those officials and employees will be maintained. It is evident that the people's confidence and trust are eroded when the conduct of the state's business is subject to improper influence or even the appearance of improper influence, end quote. The ideals stated in this section of state law really ring true for me, and that's why I'm bringing forward this bill to update our state's ethics laws in two targeted ways. First, cryptocurrency is a growing investment strategy, with 1 in 5 Americans owning crypto, such as Bitcoin. Nearly all cryptocurrency is an investment, with only about 2% of crypto actually used to make purchases. While crypto has been growing in popularity, we've seen a rising number of pieces of legislation on crypto policy introduced in our legislature. Maryland taxpayers deserve to know that their state leaders are not enriching themselves from the official actions they take. That's the reason we currently require disclosure of stock ownership, because there exists the potential for a conflict of interest. That same potential for a conflict of interest is true for an official's crypto ownership. Notably, members of Congress, their staff, and federal executive branch employees are required to report cryptocurrency holdings on their federal ethics filings, and additionally, 2 states have enacted similar requirements. Second, the bill would update our ethics law by requiring reporting on the finances of a domestic partner wherever reporting requirements already exist for a spouse. Currently, public officials must disclose information about their spouse's employment and financial assets, like stocks, as I just mentioned, but are not required to do so for a domestic partner. Maryland formally recognizes domestic partnerships in both our estates law and in healthcare settings. In both cases, recognition of the domestic partnership hinges on the partners having intermixed their finances. This bill would provide transparency for domestic partnerships, as is already required for spouses who are married. In conclusion, HB 549 is a bill to promote good government and to promote transparency, and I think that it will help build public trust in our state government. And I'm sorry, I did just want to also add, I know that the State Ethics Commission provided informational testimony. From my conversations with them as I was working on drafting this legislation, they made very clear to me that they don't take positions on the substance of the ethics laws, that they really do defer to what to the General Assembly to make those policy decisions. They really were just weighing in on what it would take from an IT perspective to implement the bill. Thank you.
Do we have questions for this witness, for the bill sponsor? Delegate Lehman.
Thank you, Mr. Chairman. Thank you, Delegate Polakovich-Carr. Always good to see you. Just curious if any other states have similar requirements in their ethics laws.
I'm not sure on the domestic partner piece. That's one I haven't had a chance to research in other places, but my guess would be yes, because we aren't the only state that legally and formally recognizes domestic partnerships, but I can circle back on that. In terms of cryptocurrency assets, yes, 2 other states have enacted it. There is legislation pending in other states at the moment.
That is the virtual currency piece, and that there's a growing interest, I can assume, in that.
Yes.
Thank you. Thank you so much.
Delegate Wilson.
Thank you. I guess my curiosity is, I see in 2008 we began recognizing domestic partnerships as an alternative to marriage. Do you know if there's a process for dissolving a domestic partnership?
Yes, actually, I just was looking at this in statute, and the provisions that are in the Estates and Trust article, 2-214 of Estates and Trust does speak to that. In the health article, I don't believe they have a process for dissolution, at least from what I read, but we can double check. That's Health 6-101.
Well, because my only concern is obviously that just trying to find out under this statute, what would, once you're a domestic partner, are you always a domestic partner? Because as far as dissolving, I know there's no divorce or anything of that nature. We don't recognize it as a form of marriage. So I just didn't know how you got out of a domestic partnership. I know that you have to want to be in a domestic partnership. I just don't know how you permanently dissolve it, and that's what I was looking at.
Right. In the Estates and Trust article, it does specify, and it says that a domestic partnership can be terminated by filing a declaration, and then it says what needs to be included in that declaration. But I'll double check on the health article.
Just to make sure that this was to adopt that. And Madam Chair, I'm not sure what's wrong with your camera. I don't know if it's racist or not, but I can't never seem to get my whole face in here. Just saying.
Well, we will work with IT to fix it. Maybe it's your positioning of your chair. Yeah. All right. Okay, seeing no more questions for the bill sponsor, thank you very much. That concludes our bill hearing for HB 549. We will move on next to HB 413, Delegate Kerr.
Thank you, Madam Chair. I have with me Aaron McNeely, and I am Delegate Ken Kerr. I'm here to present House Bill 413. This is the Maryland-Ireland Trade Commission membership and termination, altered and extended. In 2024, we passed the Maryland-Ireland Trade Commission as a pilot program, and it was enacted on October 1st, 2024. The commissioners were not appointed until July of 2025, and our initial report was due in December of 2025. And you'll recall that was the first briefing before this committee when the Maryland-Ireland Trade Commission gave their first annual report. The commission expires on September the 26th. Seeing as we got the late start and that we have, as you'll recall from when we presented our report, that we've made significant progress, we'd like to make some alterations to the commission based upon what we've learned, and we'd also like an extension on the sunset for an additional 2 years. The commission currently has 2 representatives from the House of Delegates and 2 representatives from the Senate. Over the 6 months that we're operating, we found that we don't need that many elected officials on the commission. The second delegate who was appointed has not attended any of the meetings, and the Senate has yet to appoint their representative. So we've gotten quite a lot accomplished without the participation of those additional elected officials. What we would like to do is take those 2 spots on the commission and open those up to industry professionals that can give us a broader understanding of the opportunities that the commission would have in working with counterparts in the Republic of Ireland. And that is essentially what we're asking for in this legislation, is an extension of 2 years on the sunset and a recomposition of the board to allow for more industry input. And Erin McNeely, who's the vice chair of the commission, is here with me today to answer any questions you may have.
Thank you very much. Seeing no questions from the committee, and Ms. McNeely, you don't have anything else to add?
No, I'm just here to answer any questions.
Great. Okay, thank you. Thanks for being here. Seeing no questions from the committee, that concludes our bill hearing on HB 413. Thank you very much, Delegate Kerr, Ms. McNeely. Let's see. I know we. So we have 3 bills left, or 2 bills left to be heard. 3, excuse me. HB 728. Oh, perfect timing, Delegate Harrison. Right on time. HB 636.
Good afternoon to the new committee, and I appreciate the opportunity to be here. For the record, I am Delegate Andrea Fletcher Harrison, and I am pleased to present to you HB 636, Public Ethics. And you can read the rest of the title. And I will not read my testimony because each and every one knows how to read, and it has been submitted. But I will say that for the past 7 years and going into this 8th year, I've had the honor of serving here in the General Assembly, the Maryland General Assembly. And during that time, I have seen firsthand the dedication, sacrifice, and financial realities faced by those who choose public service. This bill addresses a narrow but significant issue, and that is the inconsistency in the law that allows an individual to hold a state or local government position if they obtained it before an election, but restricts that same opportunity if pursued after honorably serving a full term. So in other words, the same job in the same agency with the same qualifications are permissible if you have held that before an election, but it's questionable after service solely because of timing. So in short, currently the law states that any members or candidates are generally prohibited from receiving earned income from an executive unit of government, with the exception of some merit positions and a few other positions. But this adds a narrow but reasonable exception for an individual that enters after having served one full term in the General Assembly. It creates a fair opportunity to compete. The position must have clear and objective qualifications, and the individual must independently meet those qualifications, just like any other applicant. So just to tell you a little bit, there are individuals, we all have come from different backgrounds. We're business owners, we're attorneys, other leaders and professionals, working parents, and some of us are even former legislators and other aspects of government, other bodies of government. Myself, I served 10 years on the Prince George's County Council, and before that I was 6 years as a staff member for a council member. That's 16 years of service, and because I was an elected official at the time that I applied or I filed for candidacy, I'm prohibited from serving in government. basically. Not only that, I'm also prohibited from serving in some private entities. For example, I had the opportunity to work with a private company just pulling building permits and was prohibited according to our Ethics Council. So this bill basically just says that after serving one full term, which is 4 years, long after a 12 to 18-month cooling off period that you would normally have serving in government, that you would not be prohibited from obtaining a position in a government entity as long as you compete for it, that it is fully it's fully prescribed, and you compete just like any other person who is competing for the job. It does not change anything to the lobbying restrictions, conflict of interest laws, and other safeguards. Basically, what we need to, an individual should not be prohibited from obtaining work, basically, which basically has happened for some of us. And we all in this body have witnessed a high turnover of legislators over our term, because I would argue that many people are looking for income stability. And quite honestly, our salaries alone don't allow that. And with the restrictions that we have, it becomes a little prohibitive to take care of our families on this. And so it's, as I said, it's not changing any ethics. The risk of corruption does not happen just because you have a position. The risk of corruption becomes when someone chooses to do so. And so I would just ask for a favorable report on this particular legislation. My written testimony has been submitted, and I thank you for your time.
Thank you, Delegate.
And Mr. Fisher, you missed my whole spiel.
Delegate Terrazza.
Thank you, Madam Chair, and thank you, Delegate Harrison, for bringing this bill. As one of those people that this restriction has applied to for the last 8 years, I really appreciate you raising this issue, because it's a very sort of niche little issue that is affecting some of us a lot. My one question for you, though, is why for a full 4-year term? Why not use the same time frame that you need to stay out of other industries, et cetera, like 18 months or whatever it is?
I just thought that it would be just a good, fair term without raising, a lot of questions or eyebrows. One full term, I think, gives individuals an opportunity to really understand what it is that we're doing here. You build up more expertise as well, and quite honestly, you're a little bit more valuable.
Just a quick follow-up on that. So I guess as somebody who had 12 years in state government, in county government, I had a lot of expertise in a lot of things that did not conflict with things that we were doing here. And so I just wonder, and I'm not sure anybody else is going to think this way, other than those of us that has affected so deeply, whether shortening that time frame is something you would consider.
I would accept that as a friendly amendment.
All right, thank you.
Yes, and I would say that, if you don't mind, if I was a policy director for the previous council member, had I filed for office and been elected while I was the policy director, I would have been able to keep that job. But as an elected official serving 10 years, and when I filed for office, I was prohibited. So it's a little, It's an interesting aspect of fairness, I do believe. If I'm ethically responsible to have that job, then why wouldn't I be ethically responsible to hold it now?
Thank you. Delegate Lehman.
Good, okay. Thank you. Is that better? Thank you for bringing the bill. It's an important issue, and it's why I'm glad to be a co-sponsor. So 2 quick questions. So one is, if this passes, there would no longer be a review on a case-by-case basis by the Joint Ethics Committee for outside employment.
No, it doesn't change that.
It doesn't.
You could still, they still have that opportunity to do so.
But would it be automatic, or they would exercise their judgment on whether to look?
That's a good question. I don't think that we actually considered that particular piece. It's just that they currently do have that opportunity.
Right.
And so that part, we weren't changing any of that. So none of that should change based on the way that we have it written.
Okay, that's helpful. And I had a second question. I can follow up with you afterward. Oh, I wanted to know if the Ethics Committee has a position on the bill, or are they not likely to weigh in on something like this? I'm just curious.
I have not heard from them, and so I'm assuming that they just weren't going to weigh in.
Okay, thank you. Thank you, Madam Chair.
Thank you very much. Delegate Schmidt?
Thank you, Delegate. I'm looking at the bill. It's a short bill. I'm not sure it says anything about you have to wait 4 years. Did I misunderstand?
One term.
You have to wait. So you're an elected official. You leave elected office. You have to wait 4 years. I'm confused.
No.
Help me understand here. Because
yes.
I don't see it in the bill, so maybe I'm misunderstanding the testimony.
I'm sorry.
Go ahead.
So on page 2, it says that the individual entered into having served at least one full term in the General Assembly. So the way that we have it written, if after one full term, an individual, if I were to apply for a position, I should not be prohibited. So the way that it's written, it's just that you have to serve one full term.
Okay.
So I termed it as a cooling off period, but that's just my own personal terminology.
I'm still confused. So you serve a full term, 4 years, or let's say you're appointed and you serve 2 years. Is there a correlation there? And then you want to leave office and work for a state agency?
No, this is while
serving, in office.
While in office, yes.
I understand that.
While in office, after one full term,
you can then work for a state.
Yes.
Now I understand. Okay. All right. Gotcha. Thank you for explaining that. Thank you, Madam Chair.
Thank you very much. Delegate Schindler?
Thank you, Madam Chair. Thank you very much for bringing the bill. I definitely share your frustrations with just employment in general while trying to serve in the legislature. But I guess my question will kind of piggyback on Delegate Schmidt's is, what's the significance, whether you could concurrently work while you're serving after a day or after 4 years? What's kind of the correlation on that 4 years?
So 4 years was just a number to grab, just as Delegate Terraza asked. As I said, I'm calling it a cooling off period. So, many times after you leave office, you have a cooling off period before you can go and work for, say, a lobbying firm. This just says that if having been in a state entity before, state government, like I was a county legislator, after 4 years in the General Assembly, I would then have the opportunity to go back to the county and apply for a position, and as long as I meet the criteria, I should not be prohibited.
If I may follow up, but you're assuming you would still be serving in the legislature?
Correct.
Okay, thank you.
Yes.
Thank you very much. Delegate Terraza, I don't know if, okay, just want to double check. All right, seeing no more questions from the committee for the bill sponsor, we do have one virtual person, Dr. Kashina A. Cross, prepared to join us virtually for testimony.
Thank you, Madam Chair, and thank you so much to the delegate for bringing this bill to us. This is an opportunity for us to enact change, an opportunity for us to have growth, and it's also, I'm asking for a favorable on this particular bill because it allows us to depend on public trust. The strength of Maryland government rests with the public confidence that decisions are made free of undue influence and perceived conflicts. And for this reason, I do support the bill. The transparency and the ethical clarity which is required for public disclosure allows us to be ready participants in the political as well as the inclusive compensation structure for those that serve us so diligently in our legislative bodies. We do need to have the Joint Ethics Committee prior approval, but I believe that these extensions will find themselves favorable in public accessibilities as well as establish a periodic review which will ensure a continued compliance. This particular bill I am favorable for House Bill 636 because it allows many public officials who wouldn't ordinarily apply for these positions because of the low amount of pay to actually have an opportunity to extend beyond their current service to more public service levels and maintain careers that predicate elected service, and that's the key. For careers that predicate elected service, many people are not only losing their certifications, but they're also losing the additional funding necessary to support their families. Maryland will benefit when leaders bring real-world expertise to public office. This is the strength of this bill, and I thank you, Delegate Harrison, for bringing this bill to the floor because you are expanding the exemptions without guardrailing any risk and undermining the confidence of lawmakers and the compensation entitlements directly affecting our legislative actions. I request a favorable for this committee. Thank you.
Thank you very much for your testimony, Dr. Cross. Seeing no more questions from the committee, this concludes our bill hearing on HB 636. Thank you, Delegate Harrison.
Thank you.
We will move along to Delegate Baylor, HB 728.
Good afternoon. Colleagues, friends, Delegate Fisher. For the record, I am Delegate Dylan Baylor from District 30A, testifying in support of House Bill 728, my last bill in this committee this session. Thank you all for your service. This bill is a relatively straightforward bill. It's rooted in conversations from Preservation Maryland, but also from my prior role at the Department of Natural Resources. If you're not aware, the Department of Natural Resources has a procurement exemption in law specifically related to conservation services. And that procurement exemption has really allowed them to be able to form more direct partnerships with amazing organizations like Preservation Maryland. And that work has, taken place on state parks and a variety of other areas. So through conversations with Preservation Maryland, and you'll see some other supporting testimony, what the aim of this bill is, this bill intends to expand that procurement exemption to a few other state agencies, including the Department of General Services, the Department of Housing and Community Development, the Department of Planning, and the Department of Transportation. You'll also notice that there are some significant oversight measures that we also put in the bill, including that if one of the new agencies decides to move forward with this new exemption, that in that contract there has to be very specific reporting requirements on the expenditures made, and that any sort of subcontracting as a part of that partnership has to also meet all requirements under state law. I think the other thing that Nick might talk about from Preservation Maryland is that this is also kind of modeled off of what the federal government does, where they are really allowed to form direct partnerships on this specific type of work. And I think the one thing that I've seen from my work at DNR and through working with Nick is that this is such a specific niche subset of the work that our state does, that there are very few entities that are able to do it. And I think more than just that, as we kind of head into the 250th anniversary and the 400th anniversary of our state, I think this bill has the opportunity to serve as a further commitment to funding and supporting historic preservation along with archaeological and conservation service work across the state. So with that, I'm happy to help answer any questions and would respectfully request a favorable report. Thank you, Madam Chair.
Well, I appreciate the opportunity to testify. My name is Nicholas Redding. I'm the president and CEO of Preservation Maryland, and it's good to see so many friends on this committee. As Delegate Baylor said, this is pretty simple legislation in that there's no fiscal impact, no impact to local government, local business. It came from a desire from both Preservation Maryland and other nonprofits that we heard from other agencies that wanted to have partnerships like the one that we have with the Department of Natural Resources to tackle like small little niche projects that sometimes don't fall well into existing grant programs, feasibility studies, helping to kind of manage a small archaeological project, things that are small but are important to kind of be the first step to getting something done. And then we quickly realized that there's no authority to do that. And so the projects kind of fall by the wayside. Oftentimes there's small pots of money that they could use to tackle these sorts of things, and they're just not able to deploy them. As Delegate Baylor mentioned, the legislation requires any subcontracting to be fully competitive. I thought it was interesting in the fiscal note that they said that might be hard for nonprofits. It is, but I think it's also very important, and it's something that we and other partners will be committed to doing. And we know it works because we're doing it right now with the state of Maryland. We're doing it right now with federal agencies. We have 2 cooperative agreements with different federal agencies and are doing this work. And we're part of a large network of nonprofits that work cooperatively with federal agencies. You'll see in written testimony the bill is supported by DHCD, by Maryland Department of Planning. Several heritage areas also submitted letters of support. And I would echo what Delegate Baylor said. In this, the 250th anniversary of the nation, a favorable report here is a vote to support a essentially cost-free way to save more history faster and more effectively. And again, I ask for a favorable report. Thank you.
Thank you very much. Thank you to the bill sponsor, and thank you, Mr. Redding. Seeing no questions from the committee, this concludes our bill hearing for HB 728. We will move to our last bill of the day, HB 576, Delegate Griffith. Good afternoon.
This is the most familiar I've been all year because I'm staring directly across committee room from you, so it's like the good old days. So.
Like the good old days. Good to see you.
Congratulations again, Madam Chair,
Thank you.
Mr. Vice Chair, members of the committee. For the record, my name is Delegate Mike Griffith, and I respectfully request a favorable report on HB 576, State Archives Record Service Fees. So last year, right around the end of session, shortly after, on a Monday afternoon, popped up on the State Archives site that they were going to charge a 20-cent per page fee to view land records. I work for a title company. I know lots of title companies. The estimates for title companies alone came in between $20,000 and $60,000 a month. This was going to cost these companies and would have put many companies in Maryland out of business. Not to mention attorneys, people dealing with divorces, banks, I mean, you name it. Anybody who touched land records, this would be a significant impact on their costs, which would obviously be passed on to the consumer. Realtors, my phone absolutely exploded. I called the governor's office. I called Jake Day. I called everybody who would listen, trying to find a way to slow this down, and so did many others. Thankfully, with tremendous pressure from the community, this was reconsidered and put to bed. But this still lingers out there. This could be a consideration. So what this bill does because right now, Land Records, State Archives is able to raise these fees without going through the regulatory process, just on their own, raise these fees to whatever level they wish. So what my bill seeks to do is put State Archives' fee process into the regulatory process, turn it over to the General Assembly, bringing it into the light, and making sure that elected officials are the ones responsible, who answer to the people, are the ones responsible for raising these fees. With that being said, I had multiple meetings with the state archivists. They requested amendments carving out just land records and plat records when it came to these fees. They said they were going to be favorable with amendments. If we carve out just that portion to go into land records, go into the bill with that amendment, I considered it friendly because that's the problem we're trying to solve, is make sure those fees on land records and plats do not get drastically increased overnight. We agreed to that. They came in informational, unsure about the amendment, but I do consider an amendment, which we have drafted. I believe we have submitted to committee, carve out just the land records and plat portion to go into the regulatory process, be part of this bill. But if the committee deems that all state archives fees increases must be part of the regulatory process, I support that as well. I know the Senate is also working on a solution. I do have a Senate cross-file on the bill. I do believe this bill, if passed by the House, will be part of a package of solutions on some of these issues. I urge a favorable report and happy to take any questions.
Good afternoon, committee members. My name is Shauli Sarkar, and I'm here representing the Maryland State Bar Association in support of House Bill 576. We're the largest organization of legal professionals in the state, representing attorneys from all practice areas. We support this bill as it establishes standards for any reasonable fees by archives with clear language of fee setting by regulation, allowing for the opportunity to have public notice and comment, as well as legislative review of the proposed fee. We appreciate that this does not remove the ability of archives to establish fees. Any fees should be fair and in line with comparable states without prohibitively restricting public access. The ability to access public land records is a necessary and vital component of many of our members' cases and settlements, impacting clients that range from large corporations to smaller firms and low-income Marylanders. An unregulated fee would immediately impact many practice areas, including attorneys that use these records to advise clients on business matters, deter fraud, settlement and title transactions, estate planning and administration, family law, guardianship, eviction prevention, public benefits cases, mortgage foreclosure, and tax sale foreclosure prevention, to name a few. Often, the most critical time to access land records is during the initial client consultation or initial discovery phase to obtain a clear understanding of the scope of legal issues that a client may face. Costly records fees may discourage clients from even seeking a consultation and could delay their ability to resolve legal issues. This bill would allow MSBA and relevant stakeholders an opportunity to take part in the regulations process for any future land records fee. For those reasons, we request a favorable report. Thank you.
Thank you very much. Delegate Terrazzo.
Thank you, Madam Chair, and thank you, Delegate Griffith, for this bill. I, too, had my phone blowing up over this issue last year and couldn't believe the cost that could add. I mean, one of the things that I heard Ms. Sarkar speak about is that clients might be shy or not want to come forward, but it could also, I would think, lead to a conflict for attorneys not wanting to just sort of explore all the different sort of, I've done title searches before, and you go down different pathways, and then there's another pathway, and this was going to charge you for just merely viewing them.
Correct. It was viewing, not just printing or downloading, and there were different charges based on the number of users. So if you're, as the delegate was mentioning, if you're within a title company and you're sitting across from your coworker, you might be duplicating that fee. So right. We really see that had a tough impact.
Right. And so I guess one of the questions I have for you, well, first of all, who's the Senate cross-file?
Senator Jennings.
Okay, Jennings. Okay. And then wouldn't this have, if it had gone into effect, essentially raise the cost of housing in Maryland?
It would raise the cost of not just housing, but significantly on housing, because, for example, like, again, I work for a title company. Sometimes you go through 200 pages of a land record to find the one you need. And so 200 times 20 cents, that's on one transaction, and we do hundreds a month, right? And that's just one company. And then, of course, you know, on the attorney side, obviously with legal matters, but even custody cases, not custody cases, but divorce cases, sometimes you look at land records to determine, you know, custody of the house, things of that nature. I mean, it seeps into so many parts of our economy, but it would definitely driven up a cost. So it added, just in closing fees alone, hundreds of dollars to every single transaction. And that's why the realtors support the bill, MBIA, NAIOP, the Bar, Land Title Association, and so on.
Thank you.
Delegate Schmidt.
Thank you, Madam Chair, and thank you, Delegate, for bringing the bill. This is near and dear personal to my heart, as you know. I know we worked on this last year together. I do see some questionable co-sponsors on this bill that are in this committee.
I can always amend you off.
That's right. In all seriousness, would you agree that these fees, they create barriers and they prevent good title work, they prevent good legal work, and it could have held some people back from actually doing the proper research to move title properly?
Listen, I believe everybody is a professional in our industry, and I don't think that the good people in our industry would cut corners, but it could create an environment when a company's fighting to hang on because of, you know, insurmountable fees like this, where they may start considering those things out of desperation. But unfortunately, the net result would definitely be an increased cost to purchase a new home, a resale, any property in the state of Maryland.
Yeah, I appreciate you sharing that. I know that there's been a considerable amount of consolidation in that industry across the state already due to the housing crisis and shortage that we're currently in.
We're seeing companies go out of business all the time right now because of the environment, and this will be just another blow.
Yep. Thank you, Delegate. Thank you for being here as well.
Thank you.
All right. Thank you very much. See no further questions from the committee for the bill sponsor for the sponsor panel. We will move on next to favorable with amendments. We have Ms. Rebecca Snyder.
Good afternoon, committee. For the record, my name is Rebecca Snyder. I'm the Executive Director of the Maryland, Delaware, D.C. Press Association. We are favorable with amendments on this bill. Delegate Griffin, I think, sketched out the horror and shock that we all had roundabout last March when suddenly land records were going to cost 20 cents a page, whether you downloaded it, printed it, or just looked at it. It's particularly an issue for press because reporters look at title, they look at that chain of custody for all sorts of things. And so, for instance, the Baltimore Banner was doing research into shell companies in Baltimore City where, some of those companies are really tangled up and having some real issues. You're seeing a lot of foreclosures now as a result of those shell companies. And that reporting is made possible by accessing those land records. And so it's not this esoteric issue. It is a real strong problem, not just for title companies, but just for getting information out about how those companies work. We're favorable across the board, but one thing that could make it just that much better, if there is in the regulatory process fees that are charged for land records and other records, we believe that there should be a fee waiver exemption for the public interest, much like there is in the Public Information Act. And so that would be our amendment. I'm happy to work with the committee and the sponsor if they're willing on that. It just is important to make sure that we have transparency in land records because it's such a high stakes issue across the board. So with that, I will turn my phone off and encourage favorable with amendment report. Thank you.
Awesome. Thank you so much, Ms. Snyder. Delegate Schmidt.
Yes, thank you, Chair. Last question. No. I see your amendment here. It says the state archive will grant a fee waiver for records at the request as part of a news media organization. So how do we define that? Because that,
The way it's done in the Public Information Act, you say that it's in the public interest, and I think there's probably a lot of advocacy organizations that focus on the public interest and would prefer a fee waiver. My lane is very narrow, that it is news media. There is a definition of news media organizations in statute and other, in other legislation that we could pull if that's.
there's like a registered
There's not a
position or-
registry per se, but it's, I'll have to pull it, but it's basically that you are organized for the purpose of reporting and for news gathering.
All right. Thank you for explaining that. Thank you. Thank you, Madam Chair.
Delegate Lehman.
Okay, thank you. Thank you for your testimony, and I share your concern and, strong belief that these records, that we need transparency. So the amendment you spoke of, is that in what we call, proper legislative format? Are you still working through that, or where does that stand?
I'm happy to work through it, and I'm happy to do that with you if you like.
And you're working with the sponsor on that?
We've exchanged emails, yes.
Okay, thank you. Thank you, Madam Chair.
Absolutely. All right. Going once, going twice, going 3 times. All right, seeing that no further questions from the committee, this concludes the bill hearing on HB 576. Thank you. Oh, okay. I was like, please don't play with me. All right. With that being said, this concludes our bill hearings for today. We are adjourned.